Hi, my name is Darcy Chemnitz, and I'm the Executive Director of the National LGBT Bar Association. We have just started recording this call. We get lots of RSVPs and lots of interest, but of course, life happens and dockets change, and so we make this available to individuals who have expressed interest in it the following day. This call-in will address Masterpiece Cakeshop Limited versus Colorado Civil Rights Commission. In going before the Supreme Court this term, the justices will assess whether, through Colorado's public accommodations law, Masterpiece Cakeshop can be compelled to bake wedding cakes for same-sex couples, or whether the owner's religious beliefs prevent them from having to comply with the First Amendment. This case will have a lasting effect on the LGBT movement, and we are proud to have a distinguished panel of speakers, especially Ria Tabacco Mar, who is counsel of record and attorney at the ACLU. I'm going to take a moment to give some very brief introductions and biographical information, and then we are going to get started straight away. We expect this call will go for about 45 minutes, and then we are going to ask for questions from listeners. You can email your question. We don't allow people to speak live on these calls because there's too much background noise. So simply email your question to darcy@lgbtbar.org. So it's darcy@lgbtbar.org. Allow me first to introduce Ria Tabacco Mar, staff attorney at the ACLU. She is an attorney at the Lesbian, Gay, Bisexual, Transgender, and HIV Project at the ACLU. Her litigation docket covers a wide range of issues affecting the equal rights of LGBT people, including employment discrimination and the use of religion to discriminate. And matter of fact, in 2016, Ria was named one of our best LGBT lawyers under 40 bar organization. I guess we were prescient there. Prior to joining the ACLU, Ria served as assistant counsel at the NAACP Legal Defense and Education Fund, where she participated regularly as amicus curiae on varying cases, including, and is a member of the board of directors of the New York Civil Liberties Union. She was an associate cravat. There is much more bio on her. You are very welcome to look her up. Adam Unikowsky is a partner at Jenner & Block and is going to moderate this conversation. Adam litigates cases in the U.S. Supreme Court, the appellate courts, trial courts, and administrative agencies. At the U.S. Supreme Court, Adam won 5 cases as lead counsel over the court's 2015-16 and 2016-17 terms. He conducted oral arguments on behalf of petitioners in 3 cases in 16-17, leading to unanimous victories in all 3. Who can say that? Adam also was lead counsel in 2 major cases in 2016. He has clerked at the U.S. Supreme Court for Justice Antonin Scalia 2010 to 2011. And then our very own Tobias Barrington Wolff, who is a professor of law at the University of Pennsylvania School of Law. And those of you who come to our annual conference know of Tobias' support for our organization. Tobias, thank you so much for all you've done over these many years supporting the LGBT bar. Tobias writes and teaches in the fields of civil procedure and complex litigation, the conflict of laws, federal jurisdiction, and constitutional law. He has co-authored with Linda Silverman and Alan Stein, Civil Procedure, Theory and Practice, and his recently published articles include The Civil Rights Reform in the Body, which was published in Harvard Law and Policy Review. Another article, Redeeming the Missed Opportunity of Shady Grove, with Stephen Bank, the University of Penn Law Review, and Federal Jurisdiction and Due Process in the Era of Nationwide Class Action, which is University of Penn Law Review. He has served as counsel or counsel for amici curiae in many civil rights cases seeking equal treatment under the law for LGBT people. He won the A. Leo Levin Award for Excellence in an introductory course in 2009. Not a lot of props can say that. And we are very excited to have the 3 of you here with us today. Again, questions to darcy@lgbtbar.org. And I will give it to our moderator, Adam, to take it away.
Thank you very much for that kind introduction. And so I guess I have my first question panelists is this. This case has gotten a lot of press as kind of a binary choice. You know, either the petitioner, the bake shop, is going to win, or the same-sex couple supported by the Colorado Civil Rights Commission is going to win. But it seems to me that in terms of the legal rule that the court adopts, there's a wide range of options. There's broad holdings and narrow holdings. So it might be helpful if the panelists can sort of walk through what are the different types of legal rules that we might see from the court and what their implications would be.
Well, I'm happy to go first. Thanks, Adam. This is Ria, and thanks again to Darcy for that introduction, and thanks also to the great degree of interest we've received. I heard a lot of beeps, so hopefully folks are dialing in. And I'm going to take that degree of interest to mean that folks are familiar with the basic facts of the case, but since I happen to unmute myself first, I'd love to just remind people of what actually happened in this case, which I think is helpful when we think about what's at stake, both on the facts of this case, but also for anti-discrimination laws on a broader scale. I think many people know that our clients, Dave Mullins and Charlie Craig, are a Colorado couple who decided to get married in 2012. And it's hard to remember that just 5 years ago, it was actually not yet possible for them to get married in their home state. And so they were planning to travel to Massachusetts to get married and have a reception back at home. And when they visited Masterpiece Cakeshop, which was recommended by their reception planner, together with Charlie's mom, who happened to be in town and who wanted to help them choose their cake, they were told right off the bat that the bakery does not make cakes for same-sex couples based on the owner's religious beliefs. So this case obviously has been pending for 5 years, and Charlie and Dave have won at every step of the way. And I think that's really important when you think about the merit of the parties' legal arguments, is that this is really a straightforward application of an anti-discrimination law. Colorado is one of 21 states that prohibits discrimination based on sexual orientation expressly. And there's nothing about this case that should change the sort of general rule that anti-discrimination laws are permissible, both under the First Amendment and also have been upheld against other constitutional challenges in the civil rights era. So I share all of that with you only by way of background when we think about how the court could rule, to keep in mind that the issues in this case really are not new. What has been framed as new is the fact that this case involves discrimination based on sexual orientation as opposed to discrimination based on race or sex, as earlier cases have done. And what also has been framed as new is the notion that this case is about speech, because, of course, the bakery has argued that its cakes are a form of art. But it's important to remember that, all discrimination could be characterized as communicative, right? I don't want to send a message that I support integration, therefore I won't seat black customers in my restaurant. But those arguments have uniformly been rejected. So again, when we think about what's at stake here, huge ramifications potentially for the LGBT community, but not just for our community, really for members of a wide array of minority groups who potentially could be subject to discrimination. So I share all of that again only by way of background as we think about possible ways the court could rule in this case. There are two primary claims the bakery is making, one based under the Free Speech Clause and one based under the Free Exercise Clause. And again, taking the religion claim first, essentially this is the argument that, because the bakery owner's religious beliefs oppose marriage for same-sex couples, that somehow that authorizes his business to discriminate in violation of a state law. And that, as I said, really is nothing but a recycled argument that we saw in the 1960s when the owner of a barbecue restaurant called Piggy Park claimed that his religious beliefs meant he could not serve black diners in the same space as white customers. We saw religiously affiliated schools arguing for the right to pay women less than men based on religious beliefs that men should be the head of the household. So nothing about those arguments is new. And if the court were to accept the notion that somehow an anti-discrimination law fails rational basis review under Employment Division versus Smith, it would be quite troubling because, of course, people hold religious beliefs about all kinds of things. And the fact that some of them, the views that we now see as sort of socially unacceptable were once quite popular does not mean there are not people who still hold them today. And, of course, the owner of this bakery holds the view that marriage for same-sex couples is not permissible, which I think is something most of the folks on this call probably don't agree with. So if there were to be a ruling in the Free Exercise Clause, again, you might imagine the breadth of religious beliefs that people hold. On the free speech side, ironically, there are a number of ways the case could be decided, but I think the potential ramifications are really much broader because, as I said, all discrimination could be characterized as expressing a message or not expressing a message. And it wouldn't be limited by people whose discriminatory views are based on some sort of religious principle. It's possible, of course, for people to have objections to serving people of different races and faiths and sexual orientations for all kinds of reasons. So that is really quite troubling. There are potential limiting principles of both the bakery and the Department of Justice, which weighed in as an amicus on the bakery side, have offered, none of which work, in our view, unsurprisingly, but do offer a potential insight into ways they are hoping to persuade the court that a ruling in their favor would not lead to the terrible consequences that we foresee. One of them would be limiting any exception under the free speech clause to products that the bakery calls expressive, or in the United States, products that are expressive that would be provided for expressive events. As an initial matter, I think it's important to remember that there was nothing particularly artistic about the product requested here. There was no product requested. Our clients were turned away right off the and the bakery had previously refused to make cupcakes for a lesbian couple. So there really was no artistry involved. But even again, when you think about the range of products that could be characterized or expressed as expressive, or the range of life events that could be characterized as expressive, while it feels perhaps is offered as a limiting principle, you could easily imagine, for example, a florist saying they won't provide an arrangement of flowers for a gay person's funeral because they object to commemorating LGBT lives. So I'll stop there. I know I've been talking for a long time in response to what was really a very straightforward question, and I'm sure Tobias is itching to jump in.
Well, thank you. I'll just add a couple of observations about the free speech arguments, which is what I've focused a lot of my attention on in claims of this type. The first is Ria mentions one way of thinking about the free speech argument here is that the act of discriminating is itself somehow expressive, that you're making a point when you turn a customer away. And that's obviously wrong. I mean, what happened here was not the equivalent of burning a draft card at a protest on the steps of a federal building. What happened here was not an act which was undertaken for the purpose of demonstratively communicating a message. This was a private consultation inside this commercial business in which a couple came in with a mother of one of the two prospective spouses and said, we'd like to retain your services. And they said, we don't serve people like you here. There's nothing symbolically expressive about that. And it's an unfortunate fact, I think, that the O'Brien case, which is the draft card burning case, seems to be the kind of, the catch-all reference when litigants who don't otherwise have good First Amendment claims want to try to wrap what they're doing in the First Amendment. O'Brien speaks of very limited, discrete circumstances, and those circumstances are obviously not present here. The issue which has gotten attention and which I think is also clearly wrong, but warrants at least a little bit more of a conversation about why it's wrong, is a compelled speech argument. And what this business has tried to do, and they're represented by the same lawyers who represented the Lane photography business in New Mexico, which is a case in which I was lead counsel at the appellate stages on behalf of Vanessa Willock, the woman who was turned away from that business. What they've tried to suggest is that when a business sells goods and services in the market that have some kind of expressive or artistic or creative dimension to them, when part of what they're selling is their skills in putting together artistic or creative or expressive products, that they have a categorical right under the First Amendment to turn away whatever customers they want to in violation of anti-discrimination laws. Because if you apply the anti-discrimination law to them, unlike the business next door, when they are forced to do business with a customer or when they're prohibited from turning a customer away on discriminatory grounds, the end result is that they are producing a product which has some kind of artistic or creative components to it, and they call that compelled speech. And I think the answer to that argument is a very straightforward one, which is that when you sell your skills in the marketplace and a customer comes to purchase your skills, you, the vendor, are not a speaker engaged in the expression of your own message. You are a vendor, and you're selling your skills, and you have skills, which is why you can sell them in the market. But the person who is specifying what the product is going to be, what the message of the product is going to be, what the purpose of the product is going to be, is the customer. And when a vendor sells their wares or sells their skills in the marketplace, they don't get to dictate to their customers what message the customer is going to incorporate into their product. That's not the nature of that transaction. This is a commercial transaction, and just like law firms are not able to hire or fire their employees based upon sex or race on the theory that they get to have control over who speaks for them, quote unquote, as a law firm, and just like private schools are not allowed to turn students away based on race in violation of federal anti-discrimination laws because they get to exercise control over the members of the community that are going to hear and speak their message in the classroom, both of which are arguments that have been tried in past generations when anti-discrimination laws have been challenged, and both of which have failed. The same basic principle applies here. This is a business selling its wares in the marketplace. And as much as it's the case that these particular business owners have very strong views about not wanting to do business with gay customers, it doesn't transform the products that they're selling into their own message. What they are selling is their skill, and that makes them no different from any other vendor in the marketplace.
So thanks for those very thorough answers. So I think that raises a question because I kind of hear from the comments sort of two different types of First Amendment arguments, two different responses to the First Amendment argument that can be raised, a broader one and a narrow one. One response is that, look, in this case, they just went into the store, the couple, and the store says, we're just not going to serve you, we're not going to make anything for you, even if it's a completely generic wedding cake from our catalog. And therefore, the argument can be made that there's no compelled speech issue here because they just had a blanket rule not serving same-sex couples. And there's another rule that says that even that there's just no First Amendment defense here that's viable under any set of facts. In other words, even if they had come to the store and said, well, we want you to design a rainbow wedding cake, which apparently they bought from the other store, and the store said, look, we'll sell you a cake, we just don't want to design you a custom designed cake that specifically celebrates same-sex marriage, even that would not be protected speech under the First Amendment. So I guess I'm curious as to whether you're advancing the narrower argument or the broader argument or both.
Thanks for that, Adam. I think, the answer has to be both for a couple of reasons. One of which is, in all candor, the remedial order that was entered by the Colorado Civil Rights Commission here does require the bakery to offer to same-sex couples any product that it would offer or that it does offer to heterosexual couples. So clearly that does encompass something a bit more than the facts of our case. What I think, though, is quite significant about the fact that there was no request for an artistic or a custom wedding cake is that it really shows that this case is not about artistry at all. And I think that the focus on artistry and the focus on free speech has been something that's really tripped up good people who are otherwise sort of opposed to discrimination but have been persuaded that there's something different about what happened here. Right at its base, the bakery's arguing this is really not about sexual orientation. This is not discrimination. This is about art. And I think the facts of this case really hammer home what the bakery's real motivation is, which, as Tobias said quite eloquently, is really not to do business with gay people. It has nothing to do with what they wanted to buy. And so I think it's important to recognize that this is sexual orientation discrimination, first and foremost, because once you recognize that, the free speech and free exercise arguments become really quite simple, since, as both Tobias and I mentioned, there have been a number of cases along these lines sort of over the years in which uniformly the courts rejected the notion that there is a constitutional right to discriminate. On the broader...
I'm sorry, go ahead.
No, jump in now.
Well, I was going to say, I'll add to that two observations about what is and is not at stake in this case. So number one, we've seen plenty of compelled speech cases where what the government does is picks a message that it likes, either because it's the government's message or because it's a message from a private speaker that it wants to give a megaphone to, and then starts dictating to private individuals that you need to serve as a billboard for the promulgation of our chosen message. Those are situations in which the compelled speech claim is very, very clear. This, of course, has nothing to do with that situation. This is a general regulation on commercial conduct. It doesn't have anything to do with picking out specific messages. It doesn't say anything about messages in the text of the statute at all. It's a standard issue anti-discrimination law that applies to all businesses that have, certain qualifying characteristics in the public marketplace. And the second thing is, and this is just a very sort of quotidian observation about how anti-discrimination law works, but I think it's important to remember, an anti-discrimination law doesn't require businesses to offer any service other than the service that they actually provide. So, for example, if you're a wedding cake company and you specialize in making wedding cakes that have a picture of the Mona Lisa on the surface of the cake, and that's just your thing, and somebody comes into the store and says, I want you to do a picture of Hulk Hogan on my wedding cake. And you say, I'm sorry, that's just not the service we provide, right? There's nothing about an anti-discrimination law which would prevent a store from simply saying, we provide one particular service, and we may have to offer our service on an equal basis to all customers or without discriminating on certain characteristics. But these are not laws that are telling businesses that they have to change the nature of the service that they're offering. And one of the features that has been true, it was true in Elaine photography, it's true in this case, I think it's true in just about every one of these cases that's cropped up, is that gay couples are going into stores and saying, we just want the exact same service that you offer to anybody else. And what these stores are saying is we refuse to provide you the same service that we provide to everybody else. And when that's what you're doing, the fact that the skills that you're selling include some kind of creative or artistic or expressive talent, which is part of the product that you offer, that doesn't enter into the analysis. What you're doing is engaging in illegal business conduct.
Okay, thanks for that answer. I mean, I guess I think that at the oral argument, it's kind of inevitable that there's going to be some hypotheticals, trying to ask you if there's any circumstance at all in which an anti-discrimination rule on the basis of sexual orientation could not be constitutionally applied. And so I'm curious as to whether you think that just the answer is no, or whether you think that there might, you'd be willing to concede that there's another class of case in which perhaps there might be a free exercise or a free speech objection, and that the rule you're seeking is tailored to this case only.
Well, so this is Tobias. Let me weigh in on that on a couple of ways. I certainly think that whatever the court's analysis is of the enforceability of anti-discrimination laws, they need to apply the same way across the board. There's certainly no warrant for some kind of special limitation or caveat on the enforceability specifically of anti-discrimination laws that protect against sexual orientation or gender identity discrimination. That would be absurd. And it's of course the case that outside the commercial context, outside of the marketplace, outside of the commercial workplace, there are some constitutional limits on the enforceability of anti-discrimination laws. And for example, the Hurley case, the Boston St. Patrick's Day Parade case, which the lawyers on the other side have tried very, very hard to press into service in this case. That's a case where Massachusetts applied an anti-discrimination law to a private expressive event, to a parade. And what the court said in Hurley, I think correctly, was, look, this is a street corner speaker. And in applying a law to this parade in a way that forces them to include parade units that they would rather not include, that's the exact same thing as telling a street corner speaker you've got to include some paragraphs in your speech that you don't want to include. That very directly violates the First Amendment. And that is sort of usefully contrasted with the application of the anti-discrimination law here, which is entirely unremarkable. And I think the answer to your question is that if you're a business offering goods and services in the commercial marketplace, then the rule is a categorical one. There's no business that is so specially involving the sale of particular kinds of talents that they get to invoke the First Amendment free speech clause. I think that offering your services in the commercial marketplace means that you are not engaged in your own active expression, and that brings you outside the operation of the compelled speech doctrine.
So, Ria, did you want to comment on that, or?
No, I think that's exactly right, and I would just add to what Tobias said that the only other example in which the Supreme Court has said that an application of anti-discrimination law did raise First Amendment problems was, of course, in the Boy Scouts case, which involved not a free speech or a free exercise claim, but a free association claim. Right. And in that case, of course, the Supreme Court said that New Jersey could not require the Boy Scouts to have a gay man serve as a assistant scoutmaster, essentially the leadership position in the organization, which of course opposed people being openly gay. And again, I think that case is just such a useful contrast to this case. The bakery has not relied on it quite as heavily as they had Hurley, but the United States, in its amicus brief, has really relied quite heavily on Dale. And of course, the bakery has no, compelled association claim, because of course they can't. There's no association here other than, again, the simple commercial transaction, which we know, the state is free to impose a variety of regulations on, including anti-discrimination. But of course, there are a host of other categories and ways in which states can, restrain, regulate, prohibit, require commercial transactions in that context that in no way infringe on anyone's expressive association rights.
And by the way, let's also not forget that businesses do have a right to engage in their own expression all day long. And if a business on their website or otherwise on the front of their store wants to say, here are our values and here's what we believe, and we believe that marriage is only between a man and a woman, and we believe that the races shouldn't mix, and whatever else they believe, they are free to communicate those ideas under whatever circumstances they want to. And so long as they're not engaging in some kind of constructive denial of service when somebody comes to the door and they're sort of effectively turned away, so long as they're abiding by anti-discrimination laws, they can communicate their views as publicly as they want to. And the operation of the market is, in many circumstances, going to lead to people choosing not to do business with a company that makes its views publicly known. And so, none of this is about silencing a business and preventing it from engaging in its own expression. It's about regulating its business conduct, and regulating business conduct is something that falls squarely within the police powers of the state.
Adam, if I might just put one gloss on what Tobias has just shared, which is I certainly agree that a business owner is free to share their views on political issues, and of course, that's exactly what Jack Phillips has done here. I think all of us know his views. He's been on national TV. He was on The View, so he has made his views known far and wide. I do think that there would be a problem if the Cakeshop were to post a sign along the lines of what Tobias outlined, because Colorado's anti-discrimination law, like many states, does have a discriminatory advertising provision, and I think a sign that amounts to saying we don't serve your kind here would violate that. I think that is plainly constitutional. The court said in Rumsfeld versus Fair, that Congress can prohibit employment discrimination, and the fact that that means you have to take down a sign that says white applicants only does not transform this into a free speech problem. So I think that's wholly permissible, but I do want to say, there are some limits on what the business itself can say, and I think those limits are wholly constitutional. That doesn't mean, however, that the business can't distance itself from its customers, and so, of course, the business might post a sign that said, provision of our products is not an endorsement of any customer. The business could say, we comply with Colorado law and we do not discriminate based on XYZ protected characteristics. I think any of those sort of disclaimers are necessary precisely because the business has chosen to open its doors to the public. When you're in the context of a business that serves the general public, I don't think there's any endorsement or attribution that really could reasonably be attributed to the business. But to the extent that the Cakeshop wanted to disassociate itself with its customers, I think there are a variety of ways it could do that, but I'm not sure it could go quite so far as some of the signage that Tobias mentioned. Of course, there are other states in which that signage might be permissible, but I don't think that Colorado is one of them.
Well, it's interesting. I wonder if that's right. I mean, to be sure, a sign that says white applicants only is an act of discrimination, right? It is saying, non-white people need not apply. If a store or a store owner expresses his values and at the same time makes very clear that they are open on equal terms to all customers, then I think the question would be whether they are engaged in some kind of constructive denial of service, whether they're doing the functional equivalent of saying, don't bother coming to our store if you're a person of the following description. And I might have a slightly more cautious approach to interpreting a store's own expression to constitute a constructive denial of service, but I think that is indeed what the question would be in that kind of case.
Okay, and I guess I have one more question before we go to the questions from our callers. This case was a little unusual in that the Supreme Court seemed to think about it for a very long time before ultimately deciding to take it. In Supreme Court E's, it relisted the case something like 10 or more times. And usually it decides pretty quickly whether to take our case or not, but here it seems to have put an unusual amount of thought into the question. So I'm curious as to whether you have insight onto why it might have done that or what that might, the implications of that might be.
I have no insight, Adam. If you figure out the reason, please let our team know. But, of course, the timing of the cert petition and the eventual decision did, span over the time when Justice Gorsuch was appointed. So, that may have been a factor. Folks have speculated that may have been a factor, but beyond that.
All right, that's fair enough. Okay, I don't know either, but I thought you might have. So,
This is Adam. I'm going to interrupt you for a second. This is Darcy.
Yes.
And for folks who are listening, do please send questions to darcy@lgbtbar.org. One question from Professor David Cruz is as follows. Could you please address the free exercise, quote, general applicability, close quote, argument pressed in the amicus brief by Doug Laycock and Tom Berg for the Christian Legal Society et al. That Colorado's anti-discrimination law falls under Lukumi rather than Smith. That is to say, so long as the statute contains even one exemption, it constitutionally must include religious exemptions. Would one of the three of you please like to take that one?
I'd be happy to take that. And just to be clear, in addition to Doug Laycock's brief, the party itself does argue that the Colorado has not applied its anti-discrimination law in a way that is neutral and generally applicable, which is, of course, an effort to avoid the rule in Employment Division versus Smith that only rational basis review applies to its challenge, and it's an effort to trigger strict scrutiny. And I say as applied because, of course, there is no argument that the anti-discrimination law on its face is not neutral or generally applicable. And when it comes to, exemptions from the law, the law does have an exemption for churches, mosques, synagogues, and other places that are principally used for religious purposes. And so it's a little bit turning that exemption on its head to claim that because the statute has actually aimed at accommodating free exercise, that somehow that means that a for-profit corporation whose owner happens to hold religious views should also receive an exemption. And the bakery has never contested throughout the state court proceedings the fact that it is not a place principally used for religious purposes. But I think the sort of far more pernicious argument is the notion that somehow the statute is not generally applicable because there were a number of sort of, prank cases that were triggered when a man named William Jack, during the pendency of this litigation, visited a number of bakeries in the Denver area and asked them to make cakes with various derogatory inscriptions or pictures about gay people. And when the bakeries refused to make those cakes for him, he then filed complaints with the Colorado Civil Rights Division, claiming that he had been discriminated against based on his Christian religion. And the division then found essentially no probable cause after an investigation that discrimination had occurred and closed those cases. And then again, during the pendency of this litigation, the bakery here then cited those determinations as supplemental authority, claiming that somehow because the division found no violation of the statute in those cases and found probable cause to believe discrimination had occurred in this case, that somehow the statute was not generally applicable, or that it favored, secular beliefs over religious beliefs, or that it favored support for same-sex marriage over opposition for same-sex marriage. And of course, the refusal this ties very nicely into Tobias's point about how anti-discrimination laws work, right? A bakery or any other business that's open to the public is free to have sort of general rules about what kind of products they will and won't sell. So, for example, Masterpiece Cakeshop says it doesn't offer Halloween-themed cakes because it's contrary to its owner's religious views. That's fine. They don't make Halloween-themed cakes for anyone. And, of course, the Anti-Discrimination Act doesn't say anything about that. And so, likewise here, it's fine for a bakery to have a policy that says we won't make cakes bearing XYZ inscription or XYZ message, as long as that is not used as a proxy for status-based discrimination, which the division found after a factual investigation, there was no reason to think had occurred in those cases. So, that, I think, is the far more pernicious view, because when it boils down to it, it really amounts to a theory that, because anti-discrimination laws prohibit discrimination based on certain identity-based characteristics and not other reasons, that there's something not neutral about that. And, of course, that would take down all anti-discrimination laws.
Yeah, I have to say that, this argument has been made in a variety of contexts, and I find it singularly unpersuasive. There's a case called Stormans a few years ago in which the Supreme Court denied cert, but there was a dissent by Justice Alito involving whether pharmacists could object on religious grounds to dispensing the morning after pill. And the argument was made that the law was not generally, so there's a generally applicable law requiring all pharmacists to serve this, and the argument was made that because a pharmacist could fail to serve a customer if the customer didn't pay, and the pharmacist couldn't fail to serve a customer because of his religious beliefs, that meant it was not generally applicable. That struck me as just crazy, but it seemed that Justice Alito bought it, and so, but I think it's kind of one of the least persuasive arguments in the case from my perspective, which is maybe why the petitioner didn't really focus on it. Although I guess...
Yeah,
I'm so glad you mentioned Stormins, Tobias, because that actually reminded me, in reference to Adam's earlier question about the relist. You know, Stormins was a case that was relisted, I think, perhaps 8 or 10 times before it ultimately ended in a denial of cert with a dissent from Alito. And so there was speculation when this case was relisted that something similar might have been afoot. Of course, that's not how it turned out, but thank you for reminding me of that.
There is an element of constitutional chicken that advocates of very extravagant free exercise claims seem to be playing, and Professor Laycock is perhaps one of the proponents of this strategy that, you know, if we can't get Smith overturned, and if we can't get strict scrutiny anytime a person of faith claims that the application of a neutral law is substantially burdening their religious belief, then we're going to try to press on the free exercise apparatus in the way that it currently exists so as to render it unsustainable. And I don't think it's going to work. I agree that it's a fairly unconvincing argument, but maybe that's an unfair characterization that Professor Laycock would reject, but from the outside, that certainly is what it looks like.
Well, one thing just to pile on there, you know, in addition to the argument that the application of Colorado's Anti-Discrimination Act would trigger strict scrutiny under Lukumi, you know, there's also a hybrid rights claim advance, which of course is the notion that was mentioned in passing in Smith that where a free exercise claim also presents some other constitutional concern, that somehow the combination of those two claims should itself trigger strict scrutiny. And as we say in our brief, you know, there's no support either in passing in Smith or really in logic for the notion that sort of two unsuccessful claims add up to more than the sum of their parts. But it's also important to remember that we're not afraid of strict scrutiny. So all of these efforts on the compelled speech and free exercise and hybrid rights, they're all in an attempt to trigger a more stringent form of judicial review, which of course the Cakeshop thinks means that they will win. But in fact, you know, before Smith, the court applied strict scrutiny to anti-discrimination laws, and those laws survived. So there's nothing about strict scrutiny that somehow means that application of an anti-discrimination law would not survive. In Bob Jones University, of course, the university sought to maintain its nonprofit tax exemption despite its racially discriminatory policy opposing interracial dating and opposing students who advocated interracial dating. That case involved the application of strict scrutiny, and the IRS's policy was upheld. There were other cases in the 80s involving clubs open to the public, like the United States JCs, that refused to promote women to leadership positions. Again, strict scrutiny applied, and the laws survived. So all of these efforts really amount to nothing more than an attempt to trigger a form of review that anti-discrimination laws have already survived. I think it's important to remember that.
Great. This is Darcy. Thanks for going through David's very well put together question. Here's a much more brief question as it relates to constitutional doctrine. This attorney, who's a government attorney, is interested in the, quote, constructive denial, close quote, issue that was raised earlier. And this attorney is wondering if there's any significant case law to that effect. Would you like to entertain that question, folks?
So I'll jump in. I'm not familiar with any, and in all candor, you know, when I said I thought the signs of the kind that Tobias was describing would be illegal, I was referencing a specific provision of the Colorado Anti-Discrimination Act, a separate provision, which is not an issue in this case and has not been challenged here, but it does prohibit certain forms of discriminatory signage. And so I read that provision as covering the types of signs that Tobias was describing, and I think that as applied to those signs, that provision would also be constitutional. So I don't know that it would be necessary to sort of do the constructive denial analysis that Tobias engaged in, but perhaps if he wants to say more about that, I will, of course, turn it over.
Sure. So I'll be honest to say that I haven't recently taken a look at case law in this area. It's an issue that started cropping up in the aftermath of the enactment of the Civil Rights Act of 1964. And sometimes, of course, speech activity that has conduct associated with it can entail a denial of service or a constructive denial of service, right? Confronting people at a store entrance and so forth. And the question is, if a store or a business uses signage that, while it's not physically confronting people with an obstacle to coming in the store, does things like saying, for example, people of color are not welcome here, and we will abide by the anti-discrimination law, so if you insist upon coming in, we'll serve you, but we are letting you know in advance that you're not welcome here. So one could characterize that as the business just expressing its views, but there's a pretty strong argument that it's also engaged in a certain kind of conduct, which is constructively placing an obstacle or a powerful dissuasion in the way of customers who are people of color. And so that's the type of claim that one would explore if a business expresses its views and doesn't just limit itself to saying, here are our values and here's what we believe, but does it in a way which rises to a level of sort of direct confrontation with customers that would qualify as a constructive denial of service. So that's what I think the issue would be in that type of case. And I don't have off the top of my head any insight to give about what exactly the case law looks like. I've looked at the cases before, but it was years ago.
Adam, is there anything you would like to add to that matter?
No, I think that covers the water.
Okay. Do you have additional questions, Adam?
I think we're about out of time. So unless there's a listener who has additional questions, I think we're about out of time.
I think those are our best constitutional questions. We've received some more practical questions. We believe oral arguments are December the 5th. When is expectation of opinions? Could we just get some calendar points on that? Are we going to hear about this in June?
Yes, I think we will not hear about it until June. It's correct that argument has been scheduled for December 5th. While we were on this call, the Department of Justice filed a request to participate in the argument, so we may be hearing from them as well. And I should also say that amicus briefs on our side will be filed next week. We've got a really terrific array of voices, so look out for those and for them to be promoted in the media. But yes, December 5th, and then, as you all know, likely not until late June.
Yeah, I agree.
Right.
This is the sort of case that is almost guaranteed to be on the last day or one of the last days of the term. And June 26th is sort of a big day for gay rights law, given that's the day of Lawrence and Windsor and Obergefell, and also the case Pavin versus Smith last term. So we'll see about June 26, 2018, if it'll be as good a day or not. So certainly, I hope so.
Has lead oral advocates for each side been determined and filed yet?
So on our side, we have filed a motion for divided argument. So I may or may not have mentioned that Colorado is also party to this case through its Civil Rights Commission, which is represented by the state solicitor general. So ordinarily, of course, respondents would only be allowed one advocate. We have made a motion asking the court to divide that time 15-15. We have not yet gotten a decision on that motion, and if past experience is any lesson, those motions typically are not ruled on until perhaps 10 or 14 days in advance of the argument date, so we may not know until that time.
Right. And then other pending appellate cases that we should be watching that are similar or ancillary to this?
If I could just flag, there's this Neely case from Wyoming, which I thought you might want to comment on if you followed it.
So that's a reference to the case of Judge Edith Neely, who was disciplined by the Judicial Ethics Commission in Wyoming for performing marriages for different sex couples and refusing to do it for same-sex couples. There were a number, I should say, of judges and magistrates and other folks of that variety in the sort of immediate aftermath of Obergefell. And that case made its way up to the Wyoming Supreme Court, and I believe the cert petition has been filed or will be filed. There is also a petition for cert pending in Arlene's Flowers, which is a case essentially identical to Masterpiece Cakeshop and Elaine Photography, only involving a florist. The florist there is also represented by ADF, and in its cert petition, ADF asked the court to combine the case with Masterpiece Cakeshop. I think it is extremely unlikely that will happen, given the briefing on the cert petition is still underway, and that would require rescheduling the oral argument in Masterpiece. But nonetheless, that is out there, and I should say the ACLU also represents the couple that was turned away in that case.
Great, thank you. I think that's the sum total or aggregate of all of our questions thus far. Adam, is there anything in closing you would like to say, sir?
Yeah, I guess I'd just like to wish you the best of luck. I mean, obviously, based on this call, Ria, you're incredibly knowledgeable about the issues, and you've thought about every single angle. So I think there's a pretty good chance the court would grant your motion for divided argument, given that usually private and state petitioners are in a very different position in terms of their institutional interests. So, and if you do argue in front of the court, I certainly wish you the best of luck, but you do seem incredibly prepared. So good luck.
Very good. So in closing, the National LGBT Bar Association would like to thank our speakers here today. And Unikowsky, very much appreciate you handling these matters and these calls for us in the past. Again, Ria Tabacco Mar, who is counsel of record and the attorney at the ACLU, thank you. And Tobias Barrington, Wolff, professor of law at the University of Pennsylvania School of Law, thank you so much for being here. We cannot continue putting together quality programming like this call without your listeners' continued support. If you'd like to see more legal analysis, please become a member of the LGBT Bar or renew your existing membership. To learn more, come to our website, lgbtbar.org. Thank you all for joining us, and goodbye.